Every day in the USA, people find themselves in court.
Court is on the record in City of Conneaut versus Ricky L. Harris, case number 25 TRD 28. This case is set for a plea hearing today. It's actually set for a jury trial this coming Thursday of this week. The court received a notice in motion filed by the defense this past Friday, July 18th. And the court went ahead and hurriedly scheduled a plea hearing for today. Pending against Mr. Harris is a charge of failure to stop after a non-public road accident, a violation of Section 335.13A1 of the Conneaut City Ordinances, a first-degree misdemeanor. Mr. Harris is present. He's accompanied by his attorney, Philip Heasley. Also present is Law Director John Lewis. Mr. Lewis, the court has received a status report.
Thank you, Your Honor. The offer that we have discussed here, should the court be willing to accept this, would be an amendment of the charge to the charge of failure to stop after an accident involving the property of others. It is still a first-degree misdemeanor, and that is under Ordinance 335.14A. The difference between this charge and the original charge is that this charge does not carry a mandatory license suspension. I discussed that this amendment with Destiny Kreider. She is the individual whose car was struck back in December 21st of 2024. Actually, I discussed it with her. She was not concerned about the license suspension at all. All she's asking for is restitution for her vehicle that was damaged. I have for the court an estimate from West Penn Collision. The damage to this vehicle, which was a 2001 Chevy Blazer, was the grand total for the repairs of that vehicle would have been, the estimate that she provided to me, $6,874. And I have a copy of that for the court. I also provided one to Mr. Heasley. The Blue Book value of the vehicle as of July 16th of 2025 is $1,665, and I have a copy of that also for the court and for Mr. Heasley. So what she's asking for is restitution in the amount to the order, excuse me, $1,665 in restitution. The city is recommending probation, whatever defined in court being appropriate, court costs along with that restitution to Ms. Kreider. She's present in the courtroom, Your Honor, and she is in agreement with the offer that I just discussed. Thank you.
Thank you. And the victim's name again is
Destiny Kreider.
Ms. Kreider. I'm sorry, you're not listed here in the original charge. Ms. Kreider, thank you for being here today. Did you understand everything that Mr. Lewis just outlined in the terms of a proposed resolution?
Yes.
And are you in favor of that proposal?
Yes.
Thank you very much. Mr. Heasley?
Thank you, Your Honor. We would express our appreciation on the record for counsel who is not present, Attorney Brianna Allen, and myself for the court accommodating this plea hearing, hopefully to avoid jury trial scheduled for later this week. We have discussed at length with our client, Mr. Harris, the offer. He very much wishes to resolve this matter, Your Honor, along the lines of the stated plea offer, although he is aware that this court does not have to follow such plea agreement. The main difference being, as Mr. Lewis, I think, indicated, The difference is between a mandatory license suspension under the original statute, or in this case, county ordinance, and the amended one, which involves an accident involving property rather than something other than that. We have communicated the offer. I've communicated the offer to Mr. Harris. He's aware of his rights regarding trial, which hopefully will not be necessary. And we are prepared to proceed, Your Honor. Thank you very much for the plea hearing. Thank you.
Thank you. Okay, Miss. I normally don't allow pleas to, this late in the game. We've had 1, 2, 3, 4, I think 4, maybe 5 pre-trials or status conferences, but because the level or degree has not changed, and essentially not much has changed in the way of the plea other than what was outlined by the counsel, I will allow this plea to go forward.
Thank you.
Mr. Harris, it's my understanding today you wish to plead guilty to an amended charge of failure to stop after an accident involving property of others, a first-degree misdemeanor, a violation of Section 335.14a of the County City Ordinances. Is that what you wish to do today?
Yes.
You understand by pleading guilty to this charge that you are waiving your right to a trial, which includes your right to cross-examine witnesses and to confront evidence presented against you. You'd be waiving your right to testify or not to testify without any negative connotation. You'd be waiving your right to subpoena witnesses. You'd be waiving your right to a jury trial. You'd be waiving your right to be proven guilty beyond a reasonable doubt. All of those are trial rights you'd be waiving by pleading guilty to this amended charge. Is that what you wish to do?
Yes.
You are represented by Mr. Heasley as well as Ms. Allen, as well as the Public Defender's Office. Have you had sufficient time to consult with them? And are you satisfied with their counsel?
Yes.
Are you currently under the influence of any drugs, alcohol, or prescription medications that might affect your thinking?
No.
Are you currently on probation, parole, community control, or post-release control with any court?
No.
Has anyone made any promises to you? As to a particular sentence that induced you to plead guilty to this amended charge today?
No. No.
No? And are you thinking clearly and you understand everything that's happening?
Yes.
Okay, I'm going to provide to you, Mr. Heasley, a written waiver of your trial rights and right to a jury trial and acknowledgement of effective plea. If you find that document acceptable, you can sign and date at the bottom.
I'm still writing, Mr. Harris, what the judge basically indicated is now on the record. Basically, a guilty plea shuts down just about everything regarding that appeal, and we're waiving the right to trial and everything that goes with it. Sign here, Mr. Harris. Thank you. Mr. Harris and myself have executed the waiver of trial rights and right to a jury trial and acknowledgement of effect of plea in this instant case, handing it to the bailiff. Thank you very much.
Thank you. The court does find that the waiver has been signed and submitted, signed in open court. Court does find that defendants, as I indicated, will allow the amendment to go forward. I do find the defendant's plea of guilty to the amended charge to be knowing, voluntary, and intelligent. Court will accept the guilty plea to the amended charge, and I will therefore find him guilty of the amended offense. We will now proceed to sentencing. Mr. Heasley, is there anything you or your client would like to say at this time before I impose sentence?
Thank you, Your Honor. My client, as indicated earlier, does wish very much to resolve this matter, and that basically what influenced the decision not to go to trial, which of course belongs to the defendant rather than counsel. We're aware that there is restitution to be made in this matter, and hopefully that will not be a problem. And he's aware of the possible sanctions that come along with this offense. We would hope that the court not suspend his driving privileges if possible. And where he's aware the court does not have to go along with the agreement, although we would hope that the court would. And once again, we appreciate the opportunity to plead to the lateral offense, same degree that was afforded us in this hearing. This incident happened last December, Your Honor. Mr. Harris has not reoffended in any way, and he is not likely to do so at any time in the future. Thank you very much. That's all.
Thank you. Mr. Harris, is there anything you would like to say at this time before I impose sentence?
I'm not sure I'm allowed to say, so I just hope that I keep my license. So
Okay.
I don't know what I can say. So
Okay. That's all.
but yeah.
Okay. Okay. Mr. Lewis?
Thank you, Your Honor. Just a real brief recitation. Back on December 21st, this Kreider's vehicle was parked in front of her residence in the street. It was struck by another vehicle. Officers investigated the matter, determined that the vehicle belonged to Mr. Harris. And at that point in time, they found pieces of the vehicle that were there, including a piece of a Cadillac grill ornament. And they matched it to the front of Mr. Harris's vehicle, and it fit. The piece of the Cadillac grill ornament fit perfectly. So that's how it was determined that Mr. Harris's vehicle was involved in the accident. Other than that, Your Honor, like I said earlier, all Ms. Kreider is really concerned with would be the restitution amount that we discussed previously of $1,665. She currently is she's been without a vehicle, I believe, since this accident happened. Is that correct? She's been without a vehicle this whole time. Thank you, Your Honor.
Thank you. Ms. Kreider, is there anything you would like to say at this time before I impose sentence? No? Okay. Thank you. So I think if there's a restitution component being included in, it seems, because this was not a citation that was issued. This was a complaint filed by the law director, so I can't tell from the paperwork filed with the court whether he had insurance or not, but I'm assuming since restitution is a component of the sentence that there was no insurance.
I wasn't the one driving it, so
Was there insurance on the vehicle?
I don't know. I didn't do it, so I don't know. I didn't have the car in my possession. But
Help me understand this. What does he mean by he didn't do it?
it was one. I'm sorry.
We were prepared, Your Honor, although he does wish to resolve this matter according to the offer which was just recently extended to us with trial on this matter. But he has waived his rights to.
I understand. Just tell me what happened. I understand. Just tell me what happened. I'd like to know what he's claiming happened.
Another individual, Your Honor, was operating the vehicle at the time of the accident, not Mr. Harris. But he does wish to resolve the matter in lieu of trial.
I just accepted your plea of guilty to this charge, Mr. Harris. I'm now in the sentencing stage.
Okay, I understand, but I'm being advised by my lawyer, so I'm not. That's what I said. I don't know what I'm allowed to say and not allowed to say. I'm trying to be respectful.
The judge wanted to know regarding insurance on the vehicle. The Cadillac has
I get that, and I didn't have insurance on that vehicle.
Whose vehicle was it?
Okay, so the vehicle was in my name that I used. I let my brother have that vehicle because I'm trying to help him out.
It's your vehicle.
It was in my name. It was his vehicle. He purchased it. He bought it.
Was the title transferred?
No, did not transfer the title. Am I allowed to continue to talk? Or
You can talk to your attorney. I'm trying to pull teeth here about what happened. I mean, I'm sentencing you, and I don't have all the information. Okay? Was he in the car?
No.
I feel like I'm cross-examining him. Was he in the car at the time?
No, sir.
Okay. So, here's what I'm getting at, Mr. Heasley, specifically for you. If he pleads to a charge where he's operating a vehicle in an accident, and he's not able to provide proof of insurance on the vehicle he was driving, what happens? It's a non-compliance suspension with the Bureau of Motor Vehicles. Right? I mean, I know this amendment was all about trying to avoid a license suspension, but if he pleads guilty to operation and he's not able to provide proof of insurance, then it's a non-compliance suspension. Right?
Yes, sir.
Do you have the restitution to pay today?
No, sir.
How long will it take you to get it, Mr. Harris?
About a month, maybe a month.
This case has been pending since December. You haven't been setting any money aside for that possible consequence?
I'm living paycheck to paycheck.
Okay.
I have 5 kids, which
I'm sorry, Mr. Harris,
I'm
but take a look behind you.
I didn't do it
You just pled guilty to it.
because I'm being advised by my attorney. I asked last time I was here. I asked if I could talk, and no one's letting me talk.
Well, we've got an appeal issue right now. We got an ineffective assistance of counsel claim right now. And I'm not going to allow this thing to go up on appeal, and you guys spend all kinds of time dealing with an appeal. I'm going to leave. And you guys are going to talk about this, and then we're going to resolve it, because I'm not sentencing right now. Because I'm not going to allow you to waste your time having to deal with an appeal on an ineffective assistance of counsel claim. This case is going to a jury trial. I'm vacating the conviction. This case is going to a jury trial on Thursday. You want your trial? You got it, Mr. Harris. This case is being vacated. I'm sorry, Ms. Kreider. This case is going forward to a jury trial. I'm vacating the conviction, and we are not proceeding the sentence. This is